1 semester. It's not a lot, but I mean, we're talking about a very small class here, very small number of students. If we take that and extrapolate it, let's say that one professor at each AALS law school, with a small class of 20, used a digital statute book instead of the print book, students would save a total of $154,000, 1 semester. And then what if we took down, what if we assumed we had 10 small classes like that at each AALS law school? Well, that means in 1 semester, law students would save $1.5 million. Now, it's not clear why students ought to have to pay significant amounts for statutory materials like these. The content, as I said, is already available for free. Nobody is writing or editing anything in these statute books. And even if we're talking about a commercial publisher as opposed to somebody like me that puts it out for free, by going digital, you eliminate the cost of the paper, the printing, and the delivery. So even from a commercial standpoint, digital statute books ought to be a lot cheaper. So cost is a clear advantage. And the thing to keep in mind is that alone, everything else up being equal, ought to be enough. Right? If you got something that's just as good as the other thing and it's cheaper, then that's a good reason to use that. But cost isn't the only advantage. Digital books are much more portable. Every digital statute book is 5 pounds less that students have to lug around in their backpacks, or in the case of many of my students, they're rolling suitcases now. And also, how many of you are law faculty, people that teach classes with those detectives? Okay. I don't know if any of you teach classes with statute books, but what I see in class often is people with their laptop computers up here and then barely crammed into the remaining desk space is the casebook, and then somewhere down here on their laps they've got their statute book open. With this, you don't have that. I mean, your statute book is on your laptop and you don't need as much space. Digital books are more durable. Now, the typical statute book doesn't last more than a year anyway. It gets updated. But I have had statute books where the pages fall out, where the binders break, and it's a bit of a problem. It's easy for me because it's a call message frequently. It's not as easy for students. Now, you can lose digital materials, obviously. Your hard drive crashes or whatever. But another advantage that the digital materials have over the print book is that you can back them up. So you don't lose all your annotating and highlighting. You try to back up your print statute book, and somebody's going to be going after you for copyright violation. Not to mention, God forbid, tried to copy 2,000 pages of the statute book. So more durable, easy to back up. Digital books are more up to date. It takes time to compile the book, print it, get it delivered out to the law schools so the law students can have it. The print book that I showed you earlier, made especially for spring classes, the effective date of it in terms of the statutes and regulations was October 17th, 2008. And that is actually pretty darn good. I mean, that's very up-to-date, very quick turnover for a statute book like this. The digital statute book, the material was current as of December 29th, 2008, for a class that started, I believe, January 10th, something like that. So much more up-to-date than what you would find in print materials. And if you're talking about an area of the law where there's a rapid change, that really makes a lot of difference. Digital books are easier to navigate. This print book that I used to use has this really sophisticated navigation system. You go to the back of the book, and you see this tab index. So you find the materials that you want to look for. Let's say the Securities Exchange Act in this tab index. Then you've got to find where the little tab is. And after you do that, and by the way, those don't always match up. After you do that, that takes you to another table of contents for that particular statute. And then you got to go from that table of contents, you got to find page 715, and then you're finally to the material. And that always takes a long time to do. It takes a while. The digital statute book that I made has its own hyperlink bookmarks, nothing sophisticated. I mean, it did it in Adobe. So you just click on the statute, you click on the section, and it's there. And if you want to go somewhere else, the index is still there as well. And also in terms of ability to navigate, in the print statute book, if you don't happen to know what a section number is or even what statute it is in, you're kind of stuck. In this thing, you can search for text, and you can find the statute you're looking for, even if you don't know where it is. You have a general idea what it says. So easier to navigate. And then, of course, obviously, if you've got digital materials, much easier to cut and paste it and copy it. So if a student wants to take it and move some material into a paper or into an outline or something like that, you don't have to retype it or anything like that like you would with a print book. Well, the downside, obviously, of digital materials is you have to read on a computer screen. And I think all of us would agree, even people like me who do read novels on computer screen, that it's easier to read long passages of text in print than it is on a computer screen. Now, the thing to keep in mind, though, in terms of digital statute books, is it's not a novel that we're reading. And typically, when you're reading statutes or regulations, you're not reading long passages of text. You're doing precisely what a computer enables you to do well. You're reading sections, you're skipping somewhere else, you're jumping back and forth. And so the computer screen actually facilitates how we want students to be reading statutes and regulations. I'll talk about that a little bit more later on. The other thing, anytime somebody talks about, oh, but you have to read it on a computer screen, reading on a computer screen is hard. Many of today's students are comfortable reading on screens. I suspect a lot of the people here are comfortable reading on screens. You do it all the time. If it's not your laptop, it's your iPod, it's your cell phone, whatever. It's your Kindle. And so reading on screen is something that students of this generation are much more comfortable with than students of my generation were. Well, I guess students of my generation could have read on screen, but that's a different, as you can see from the color of the beard. So reading on screen isn't that big a deal, I don't think. But even if you think it is, it's easier to read on a print book than it is to read on screen, you still have to ask yourself this question. Is it $45 easier, particularly if you're a student on a tight budget? And at a minimum, if you're a faculty member, shouldn't you give your students the choice of deciding whether reading on screen is worth, or reading on print is worth $45 or not, if everything else is the same? Okay. Well, all of that kind of explains why I decided to do this. There's also a little bit of, I've talked about digital books in the past, a little bit of either put up or shut up. So that's why I decided to do it. I want to talk a little bit now about how I did it. And I'm not going to go into a great bit of detail on the mechanics. I have written a paper on this. It is posted on the materials on the website, so if you want to read it, there are a couple of appendices in the paper that go into great detail about our formatting and what we did and all that. If you'd rather have a paper copy, let me know. I'll be happy to provide you with a paper copy. Or I could simply tell you where it is electronically and teach you how to print. So let me talk about how I did it, just kind of briefly. First of all, the source material. The source material for this was easy. I was using federal securities law, statutes, and regulations. The federal statutes simply pulled off of the online version of the U.S. Code, which is published by the same office in the House of Representatives that publishes the print version of the U.S. Code. So you can go to that, get that. The regulations, I used ECFR, which is a joint venture of the government printing office and the Office of the Federal Register. Not yet an official version of the CFR, but you look at their website, it sounds like it's not going to be long before it is. So got the regulations off of that. And then decided to format the digital statute book as a PDF file. And obviously there's other alternatives. I could have done it in HTML. I could have done it as a Word document or something like that. A couple of reasons why I chose PDF. First of all, in terms of PDF versus, say, something like Word document format, a couple of reasons. Number one, I at least found it easier to create a hyperlinked table of contents, at least in the format I wanted, using in PDF instead of using the table of contents that Word allows you to create. I thought the PDF would work a little bit better. Number two, the Adobe Reader that people use to read this is free software. Word obviously is not. Not all the law students have Word. Not all the law students use the same word processing platform. And so that kind of swayed me just a little bit. But the important thing in terms of Word versus PDF was the table of contents. I just couldn't get Word to do what I wanted it to do. In terms of PDF versus doing it as an HTML file that students could read in their browser, I chose PDF because I thought it would be easier for students to highlight and annotate the materials than it would be in an HTML file. And I know you can get plugins that allow you to highlight things like that. I played around with a couple of those. I wasn't really satisfied. I think it works a little bit better, and you can do a little bit more in Adobe Reader with a PDF file than you can in those things. So I chose to do it in PDF. Now, once I made that decision, I had my source material online. It did take some manipulation to get from the source materials to the format of the final product. And what I did, really briefly, first basically I just took what was available online, dumped it into a Word file. And because if you look, even if you've got Adobe Acrobat Pro, you look at the help files and they say, look, we suggest you not edit this, which is, if you ever try it, it's a good idea. Use a word processor. So I use Word, so I use that. So I dumped them into Word. When I did that, I lost some of the formatting that was there online. In particular, I lost the outline indentation, where you've got 1A, 1A1, that kind of stuff. And so what we did at that point is corrected the formatting. We didn't do it by hand, line by line. If you want to know how we did it, that's in the article. Basically, we used the word outline function. We're able to do it without having to do each line by hand. And then finally, in terms of what I was doing in Word, I created automatic tags for each section number. Because I knew I wanted to do bookmarks. I wanted to do a table of contents by section number. And so I went ahead and created the tags that was going to allow Adobe to do that. And again, that was automatic. We didn't have to go down and hand tag each section number to do that. And then at that point, I converted it to PDF. Using Word 2007, and it's got a PDF add-in that does that automatically. And as far as I could tell, fairly seamlessly. They kind of changed the way the system, Adobe and Word kind of changed the way the system worked about halfway through this project, but once I got to what they had, it worked fairly well. So I then had a bunch of PDF files. I basically had a PDF for each statute, for each set of regulations, because I hadn't combined them yet, and, well, I'll get to that. Simply combined those PDFs in Adobe Acrobat, really easy to combine PDF files. And then in Adobe, took advantage of the tags that I'd already made and set up a table of contents automatically. Now the only thing I didn't have to go through this whole process for was the SEC forms that I included in the book, because the SEC has their forms posted on their website as PDFs. Posted on the website as PDFs, and so basically all I had to do with those forms is just download them directly. Didn't have to go through the conversion process. And that's basically it. And it sounds, well, maybe tech people here, maybe it doesn't sound complicated. It sounds complicated to me, but it really wasn't. It took about 2 to 3 hours for each set of statutes or each set of regulations. So we're talking a total of about, somewhere between 12 and 18 hours. I forget how many. Yeah, probably about 18 hours. You know, not a big deal if you're producing something that's going to save students that amount of money. And I should say it wasn't me doing most of those 12 or 18 hours. I should acknowledge Mark Hotzinger, who was my research assistant, did a lot of the stuff down to the Adobe part. He didn't have Adobe, so I took it up at that point. But since he's likely to read this podcast, they probably have an issue with his name, just in case. But so anyway, it's something that a research assistant can do. So we're talking about 18 hours of research assistant time. Not that expensive. Okay, so that's kind of how I created it. Let me show it to you now and kind of give you an idea of how it works. And some of this is going to be kind of showing you what you can do with it in Adobe Reader. And I apologize to those of you that are really familiar with Adobe Reader, but just kind of bear with me for a second. Okay, this, as I said, is the actual thing that I put together. And I want to mention, I am, although I do have the full version of Adobe, I'm using, for purposes of this presentation, I'm using just the ordinary free Adobe Reader so you can see it from the way the students would have seen it and see what they were able to do with that free software. You got the title page here. The title page also has some very rudimentary instructions, basically about how to use Adobe Reader, how to use the table of contents, things like that. You may think that sounds silly, but I want to talk about that in a second. As it turns out, I didn't put enough there. Over on the left-hand side, you've got the collapsible index. Each set of regulations, each statute has its own sub-index. So like if I wanted to look at any particular thing, just simply open up that index, and I could go to any of the rules I wanted. By the way, this is not my copy. My copy would have highlighting and underlining all over it. But just go to the particular, it's probably small enough that you can't read the text, but that's not particularly important. And you can, I mean, people were talking yesterday about resizing fonts. You can, of course, resize the font if, like me, you're blind, so you can see it a little bit better. Now, while we're in this, let me kind of briefly run through what students could do in terms of marking this up. Because, quite frankly, when I started this, I didn't realize you could do all these things in Adobe Reader. I hadn't done much in terms of the comment function, but you can. All that's necessary is that the person creating the PDF file, which is me, enable commenting. And what happens is a lot of people that create PDF files don't go to that extra step to enable commenting, and so these tools aren't accessible. But so I did that. Now students, if they were reading this and they wanted to highlight it, all they've got to do is select some text, right-click, highlight text, and they get it highlighted. That's actually yellow in real life. You don't like the color, or you're one of those students that's into multicolor highlighting, you can change it to any color you want. And you'll notice there's here in this box, there's a make properties default. So if you don't like yellow highlighting, you like green or something else, you can do that for all your highlighting and then just change the colors of what you want to change. It's not the default. You can underline basically the same way. Just select the text, underline. You can also change the colors of that. I wanted black underlining. And if you're really psycho and you wanted some of your underlining, squiggly underlining, well, you've got your squiggly underlining. So you can do those things. In addition to the basic underlining and highlighting, you've got the ability to create text boxes. Just click anywhere and then type in whatever text. Excuse me, I inadvertently left that while it's. Now let me create another. Proving I don't know how to spell text. Type in whatever text you want, and you can move those around anywhere you want them to appear. They've also got, if you want a text box with an arrow pointing at something, you can do that kind of stuff. If you want just arrows or lines, you can do, basically you can do just about anything you could do on a PowerPoint slide you could put in this. It's got really stupid little things too, like if you would like to draw a cloud around text, just put your cloud around the stuff the professor said is really important or something, I don't know. And then if you're really, really good with a mouse, or if you have a touch screen, it allows you to draw, write, things like that. So basically, there are a pretty good array of annotation features available in Adobe Reader that allow students to mark up their statutes. I was a little bit surprised. My research assistant, when he was talking about this, he says, well, I'm not sure I'd use those tools because I don't like to mark on my statutes because it's a book. He says, well, maybe if I had that, I would. Well, if you're in your third year and you haven't learned to mark on your statutes, then we haven't taught you very well. But in any event, so maybe students like him would be more willing to do this than they would in an actual book. My view of this is that the commenting features are a little cumbersome. They're not quite as quick, particularly if you're changing colors and things, as the word features are, but they work fairly well. Oh, there's one other tool I didn't mention. There's if you're used to the word commenting feature, you're used to the ability to basically put in collapsible notes, and this allows you to do that as well. Okay, so that's basically how the thing works. So let me talk now in the time I've got left about how the experiment went, just really quickly. First of all, from my standpoint, I used this digital book exclusively. And I used it to prepare for class, so at my desk I used it in class as we were going through stuff, and I preferred it over the printed book. Now I carried this thing to class because I had this fear that maybe it would disappear from my computer or something, or it would disappear from a student's computer. Neither I nor any of my students ever had to use the book. So I had that backup. Didn't really need it because there's my computer and the other computer in class. I can just back it up and have it. I'm just very anal about that kind of thing, but never needed it. In terms of student comments, I surveyed my students near the end of the semester, and then actually surveyed them again a little bit after the exam. 24 of 25 total students responded to the survey, and 20 of those used the digital statute book exclusively. They didn't buy the print book. Another 2 of those used them, they said about 50-50, and then there were 2 of them that primarily used the printed book, although they also used the digital book, I think just to try it out. And the response was overwhelmingly positive, and basically positive for the reasons that I've already talked about. These reasons here are in order of comments they made. Number 1 was navigability, the ability to get around in the materials. 2, as you would expect, cost. It was free. Portability, not having to lug around the statute book, cut, paste, and copy, and the ability to search for things. Well, what kind of problems did I have? What kind of negative comments? Let me talk first about problems I can't fix. First of all, as I said, I created bookmarks for the section number. Students want to create their own bookmarks. And unfortunately, in Adobe Reader, you can't do that. Now, there is a JavaScript plugin that you can go out on the internet and find that allows you to bookmark particular pages, but I'm a little hesitant about suggesting that. Next year's version is going to tell people it's out there, but it's not going to tell them where to find it. So I figure if you're sophisticated enough you have to be sophisticated enough to find it to be able to use it. The other comment, I had a couple of students, I think maybe two or three, that said that when they had the statutes open in Adobe Reader, it ran a little slow. I can understand that. It's an 18 megabyte file, and Adobe Reader itself is kind of a slow program. I never had that problem, and I tend to have multiple windows open all the time. And there's really not anything I can do about that other than, number one, wait for Microsoft Vista to disappear. And along the same lines, wait for students that have newer computers. I mean, I've got a really fast computer, so I'm not going to have any problems like that. But yeah, that was a problem for a couple of people. Although I asked them again after the exam if anything, how everything went, and I had a couple of students that said they were a little worried about using it on the exam and said they had no problems at all. So apparently it was just a problem that probably came up while they were surfing the internet in class trying to read the statutes at the same time. In terms of problems I can fix, the number one problem, if you look at these surveys, and the survey's available, the actual survey comments are available as an appendix to the article, was student knowledge. Just not knowing how to use the thing. I had a couple of students who were using Macs, and the native PDF reader in Mac is not full-featured. It does not have comments. One student told me it didn't have table of contents. I find that hard to believe, but it clearly does not have the commenting features. And so I solved that problem, moved them over to Adobe Reader. But even the people that were using Adobe Reader, some of the students, for technological generation, really didn't understand all the comment search features. So I kind of went through them in class, but there were still problems. One of the comments I got just kind of threw me. One student responded to the survey, said, it really would have been nice if there were a search function so I could search for things instead. and then I've got all these other comments that say, gee, my favorite thing was the search function. So my solution to that is going to be in the next version of the book. I'm going to put more instruction about how to do things, and I may even hyperlink to the Adobe website for people who want more. The other major problem was navigating within long sections of the statute. I bookmarked the sections, so those are easy to get to, but not the subsections. And the problem is some of that material covers several screens before you get to the next section. And students were having, they said, hey, we're trying to find subsection C, and we've got to go way through all this stuff. I think what I'm going to do, and I'm still not totally sure, but I think what I'm going to do is, at least as to the statutes, next time I'm going to bookmark the subsections as well, so they can look at these. Okay, well, really quick. The other thing I'm going to add is hyperlinks. If, like here, there is a cross-reference to another section, I want to add a hyperlink so students can go to that section. And even if there's not a cross-reference, what I would like to do is to hyperlink defined terms. And the reason I want to do that is, even though it's going to take a lot of work, is that I think pedagogically it's something students ought to be doing. Right? If there's a defined term, they ought to be going to the definition. If there's a cross-reference, they ought to be going to the cross-reference. And so I want to put that in there. Whether or not I'm going to have the time and the effort to do that is a different issue. Okay, and then one more minute, and I'll give you time. In terms of what's next, I'm going to update this and make it available. Practically, it was available now, although nobody knew it was there. I mean, it's publicly available on my website. But I'm going to make it available. Any student, any professor who wants to use it. I've already got one professor that read the article, and she says she wants to use it for her class. If you know anybody that teaches in the securities law area that might want to use it, let them know. I'd be happy to talk to them. And the other thing is I hope other people will do similar projects like this for other subject areas. Because, as I said, it really wasn't that difficult to do, and I'm not a technical wizard by any means. And it really is a great benefit to students. So If you know anybody, or if you're interested in doing anything like this and you want to talk to me about how I did it or the problems we ran into, I'd be glad to talk to you. One problem I warn you about, the material I used, none of it was copyrighted. If you're in a subject area that has Uniform Acts or Model Acts, that's all copyrighted. And I was going to put something like this together for business associations, which is almost all Uniform and Model Acts. Copyright holders are not particularly cooperative. And in particular, the copyright holder that is always decrying the cost of legal education, the American Bar Association, and I hope they get this and listen to this podcast, was very uncooperative in terms of letting me use their Model Acts. So that's an issue, depending on your subject matter, that you might have to deal with. Okay, well, thank you. We will hold comments and questions to the end, so we'll go straight to Patrick now, and then if we have any time at the end, we can ask questions and comments at that point.
No, I'm going to be standing. Is this with you?
That's fine.
I want to thank you for being here too this early on a Saturday morning, last day of the conference. Let me tell you a little bit about why I started into this, and then I'm just going to show you some of the things that I've done in terms of getting rid of the constitutional law casebook. I was moved to do this by three things that conspired to come together to actually make this a feasible project. I thought about putting my constitutional law materials online for a while, and three things, as I say, conspired to make that possible. One was that publicresource.org released a repository of federal opinions, including U.S. Supreme Court opinions from about Volume 1 up through 2005, and the Legal Information Institute at Cornell has just about everything else, which meant that I had some publicly available stuff and didn't have to worry about stupid Westlaw Lexis kind of licensing issues that I had, for some reason, been concerned about a little bit before. This keeps disconnecting me, but I don't think it matters, so don't worry about it. The other thing was, another thing that motivated me was my association with CALI and the CALI eLangdell and Legal Commons projects, to which I wanted to contribute, and so this is a way of contributing to the Legal Commons project in particular, although it hasn't made it there yet. It will eventually. And the third thing was the most recent edition of my constitutional law casebook, which frankly sucked. The cases were eviscerated, and I looked at other casebooks to see if they were more to my liking, and decided that they were not. And I won't mention the person responsible for the casebook, but I felt that the editor of that casebook broke faith with his users, because there were things like ellipses in the casebook where you would go back to the original case and you'd find that ellipsis covered material that was paragraphs and even pages apart. And that struck me as rather unfortunate, and so I decided that I was going to go online. I spent the whole academic year, the year before last, doing Con Law 1 and Con Law 2 in the fall and spring, apologizing for the casebook. And I said, and they said, well, you chose the casebook. And I said, well, yeah, but the previous edition was okay. This one is. So I got myself a grant in the summer of 2008 to start preparing online constitutional law materials for the fall of 2009 Con Law 1 course. I was almost done by the end of the summer with Con Law 1, so during the fall of 2008 I started preparing the materials for 2009, and by the time spring 2009 came around, I was about 3 weeks ahead of the class in terms of the syllabus, in terms of getting stuff edited and ready for the students to use. I'm now teaching Con Law 2 for the summer semester, and so I'm sort of updating the materials as I go. Let me show you. This is my constitutional law syllabus. If any of you were at last year's conference and happened to come to a session that I did called the Rich Syllabus, this is sort of the next step from the Rich Syllabus. The Rich Syllabus is an online syllabus with links to every class and hyperlink materials on it. But I hadn't taken the next step of replacing the actual substantive materials and that I've now done. I've already linked to the class which happens to meet on Monday. So this is a typical class page. It has a little less information than some do. But typically, my syllabus page will have notes and questions and so forth about the topic material, and then links to the edited cases. The edited cases, you'll notice, have an asterisk after them. That's to indicate to my students that the case is ready to go, which was occurring maybe sometimes as late as a week before the class. I've now cheated and downloaded the case or loaded one of the cases from my local version of it, and that's worth saying something about. I do all the development and editing and so forth on my computer, which is a Linux machine, which means I have a web server running on it, which means it's just like a web server. So then I use a program called rsync for the technical among you, that just, as I update it, I just update it to the server, and it's very, very quick. So, which means two things. It means I have a backup all the time. So let me just show you a little bit about how these cases operate. In many of the cases, you'll notice here there's a link to concurring opinions or dissenting opinions further down in the case. One thing I should mention, by the way, that this is that much of the stuff in here does not work in Internet Explorer because Microsoft, well, partly because I don't care, but partly because Internet Explorer doesn't conform to the standards that I need for the style sheets and the XPath stuff and all the other stuff to work. So at one point I tried to make it work with Explorer by using somebody else's code that claimed to make the XPath stuff work, and it was clunky and it didn't work right, so I just abandoned the hope of making it work in Internet Explorer, which, as I say, I really didn't care about. So my students now, they don't have to buy the book anymore, of course, the $140 odd book that is lousy anyway. They have free materials. And I've told them I'm hoping to wean many of you off your dependence on Internet Explorer, and I've had at least a couple of them be very grateful for my having done that. That Firefox is a whole lot faster and a whole lot better. So anyway, the ellipses. I've discovered that much of editing cases, and this is it's a peculiar kind of project because I'm a law professor who writes code, which is relatively rare. I mean, we're not unique, but it's a relatively rare thing. So the project has two aspects to it. It has doing the substantive editing so that my students are getting what they need for the courses, and it also has the aspect of writing the style sheets, writing the JavaScript that delivers the stuff the way it gets delivered. The ellipses, if you put your mouse cursor over the ellipses, you can't really see it very well, but it pops up the first 250 characters, so that you've got a clue of what has been excised. If you want to see it, you just click on the ellipsis, and there it is. So the excised text is restored. If you want to if you want to do that throughout the document, you can just click on expand ellipses and it will expand everything throughout the document. Footnotes are presumptively deleted, but there's an editorial way to undelete the footnotes that you want the students to see, but if I want them to see all the footnotes, I can click on that. And that, you'll notice that those two links persist all the way through the document, so anywhere through the document you can either collapse or the ellipses or expand them and show all the footnotes. Another thing to observe about that is that more or less restores the entire case, but not quite, and I'll explain why not quite. Some material is deleted. I should say it's deleted in quotes, by which I mean that it remains in the source, but it's coded in such a way that the browser just doesn't show it, and there's no way for the browser to show. So things like syllabus. I really don't want the students sort of clicking on an ellipsis that shows them the syllabus, because then they'll read the syllabus and they won't bother to read what I actually want them to read. So things like that, if they're sophisticated enough to look at the source, they can find the syllabus, and it's got all this coding in it, so it wouldn't be a particularly helpful way to look at it. You notice also throughout the cases there are links to other United States Supreme Court cases that are cited in the case. The link, you certainly can't read that down here, so I'll just show you. The link, if I have an edited version of the case, that's what's linked. If I don't have an edited version of the case, it will link to the original from publicresource.org. So if it's in my repository of edited cases, that's what it's pulled up. If it isn't, I have the whole repository of US Supreme Court cases on the server, so it links to those. There are occasional editorial footnotes which are indicated by letters, and the footnote is then appears at the bottom of the opinion to which it belongs. The footnote then appears within square brackets, so it's distinguished from the rest of the text. I'm probably going to put that in a different typeface as well, just to make absolutely sure that people know that that's me and not the court. For those of you who care about this thing, I've also massaged it so that every paragraph is a target, so that on my syllabus, if I want to send students to a particular paragraph in a case, I can format the URL in such a way as to send them straight to a particular paragraph in the case. I'm going to go to the end of the case. At the bottom is a footer. This one indicates that this comes from publicresource.org, protected by a Creative Commons 3.0 license, which I'll explain why that's the case in a moment. And there's also a link to the original public.resource.org version of the case if people want to go look at that. I'm showing you this one in particular because this one happens, I'll go to the end of this one too. This one happens to be really messy. The quality of the cases from PRO is sort of variable. Some of them are pretty clean and some of them are not. And the ones that aren't, this is an example of one that isn't. These are supposed to be footnotes and linked as footnotes, but they're actually just appearing as text. So I had to go through and fix that, so that we go from this, the PRO version, to this, my version. That was a PRO case, the public.resource.org case. Some cases I get from the Legal Information Institute from Cornell. This is a case that was decided on Tuesday. It happens to raise an issue that is of some interest to me in my Constitutional 1 course coming up in the fall. So I've already taken the case from the Legal Information Institute and massaged it in such a way. I like that the PRO format styling is what gives you the paragraph numbers. That's an incredibly useful feature, having paragraph numbers in class, because I can refer to the paragraphs by number in class. Incredibly useful feature. I haven't done anything to this yet other than just give it the look and feel of my cases. The editing to get that to happen probably took maybe 10 to 15 minutes, because most of it's happening behind the scene in terms of styling and JavaScripting going on that converts the LII format into into the PRO and plus me format. This is what it looks like when you go to the LOI version, the LII version. This is the opinion of the court. Obviously, it looks very different. The way I do it is I just pull up the source of the opinions, and what LII does is have each opinion in a separate file with, interestingly, footnotes numbered 1 through whatever in each file. I put them all in one file because that's the way the PRO folks do it, and of course then I have ambiguous footnotes. So I have a little piece of JavaScript which disambiguates the footnotes. But essentially what I do when I pull up the source is I just pull out the text and pull out the text of the concurrence and the dissent, etc., and then save it. And then I go in and edit it a little bit. I add links to my scripts, and I put in a title header, and that essentially, that little bit of work, and I put in the footer as well. That little bit of work converts that into this. And if you look at the footer at the bottom of that, it says text acquired from LII and has a link to LII, protected by a CC 3.0 license. The reason for that is that LII's stuff is protected by a CC 3.0 license. And if you make a derivative work, that license requires that you use a 3.0 license. things about this case is it happens to be about the tonnage clause. For those, if any of you are into constitutional law, the tonnage clause is not much litigated. Haven't been litigated in a very long time. So there are links in this. One of the things that tickled me about my coding was that is that when they refer to the eponymous, the early reporters that are known by the name of the reporter and not by one US one or whatever, I came up with a little bit of code that links appropriately to the right thing, so that it's actually 73 US 31 in the repository, but it's 6 wall 31 in the code set. It's little things that please one, isn't it? This is very much a work in progress, but let me show you some other little pieces of it. One piece. Well, let me first. Yeah. Well, no, I'll stop here for now. One of the things that I'm doing. This is a table of all the edited cases. One of the things that I'm doing that I sort of went back to do because I realised it would be a useful thing to do is every case, not every case yet, but about 3/4 of them now, and eventually all of them, have 2 meta tags. One is a terms meta tag. And one is a topic meta tag. The terms meta tag is just my sort of very brief take on what the case is about. The topic meta tag is the section in Chemerinsky's book on constitutional law, policies and principle, which I'll just show you the table of contents about. I'll zoom. See that. Oh, except I'm online, okay, offline, so never mind. But, you can see some of the, if it's about 2.2, then the topic on that will be reflected in the topic tag. I'm going to delete that, so I'm going to take the right step. So back to the table of edited cases. These are sortable. That I'm going to sort on topic. And what that does, of course, is show you how many cases are actually not tagged by topic yet, but it is about 3/4 of them are, and then we'll, by the end of the summer, have completed that. Let's see, what else do I want to show you? There's a link from the table of cases to the project description, which I'll just say a little bit about, see if there's anything I need to tell you about the features of the cases that I haven't said anything about yet. I am going to provide a way that this thing here about providing. I've noticed that most editing is about taking paragraphs out. I've done some within paragraph editing. The ellipses work within paragraphs, but most of it is removing chunks of stuff that just isn't relevant to what you want to be talking about in the case. So once these things are generally available, I've written a little code which will provide an easy way for a professor to put a query string at the end of the URL and list all the paragraphs that he wants to be excised. Eventually I'll have paragraphs you want to add and paragraphs you want to subtract, which means that somebody who wants to bother to do that doesn't need to go under the hood and actually do what's under the hood, which is putting a span around the stuff that you want to excise. And the problem at the moment is that the way I'm doing this is I'm editing the code in a text editor, right? So I'm looking at the code. Most people, that doesn't bother me in the least, but most law professors probably would prefer not to do that. So I'm going to provide an easier way for these things, for relatively crude editing. Yes, I'll talk a little bit about availability and licensing. It's sort of available in the sense that it's not hidden anywhere, and it's if you go to law.gsu and sort of toggle down to my constitutional law 2 or 1 courses, not law 2 this semester or 1 from last fall or coming up next fall, you will find a syllabus. The links on the syllabus are not publicly available, but there are links on the syllabus to both to a public version of the syllabus, which I'll show you. That's the public version of the syllabus, which just has the topics covered and links to the cases. There's one, by the way, that indicates that you can link straight to a paragraph. And the syllabus also has a link to the table of edited cases. So so it is out there and linkable to it if you want to use the cases, but it's not. I'm not sort of I am eventually going to zip it all up, send it off to Elmer, who will upload it to the Legal Commons site. At the moment, it needs a server in order to be delivered. So it's delivered from the server that sits in my office. It will be delivered at some point from the CALI server. Eventually, what I want to do, and I'm thinking about the best ways to do this, but eventually what I'm going to do is make it not require a server in order to be delivered, because not everybody has a server, but just be able to put it all onto a zip drive or USB drive or something, so that people have all the cases and all the functionality without having to set up a web server to make it work. But at the moment, that's what's required. I'll stop there. And we've got five minutes for any questions for either one of us.
What do you do? Excuse me, what do you do about the problem of access during exams? There are some administrations who don't want you to have access to a computer, but then even if you have one of the exam software, you can't access this as well.
That's not correct. All my students are required to take the exam on exam 4, and there's a setting in exam 4 which allows you to access things on your computer, but not go out on the net, and that's what we use. Yeah.
Although in this case, that casebook would be inaccessible if you didn't let them out on the net.
To access that, well, at least from exam 4, I don't know about exam soft, the others, but you'd have to let them out on the net.
You have to take open access on exam 4.
Yeah.
Which means everything on the internet would be open.
My exams are completely open, but I don't care what they use. There's only so much damage they can do in 3 years.
Don't underestimate them.
Can the students mark up the cases in your case?
Now that's an interesting issue. That was one of the things that I worried about when I well, a couple of things I worried about. Well, the first thing I worried about was I'm about to go all online in a required course, and I haven't asked permission from a dean or somebody. He had approved the grant, so he knew that I was going to be doing it, but I don't think it crossed anybody's mind that I was going all online in a required course. And I did worry a bit about that, but I guess the students self-selected because there were 3 sections. And I was expecting some pushback from the students, and I got none at all. In terms of marking stuff up, the Common Law 1 in 2008, I set up a DIGO site, D-I-I-G-O, which allows annotation and sharing and stuff. I wasn't greatly thrilled with the way that worked. You can annotate pages and the annotations persist. The problem is that if the page changes, then the annotations get lost. So it wasn't very stable. There's a very interesting Firefox extension being worked on called Ubiquity, which has all kinds of functionality, but among the functionality it has is the ability to edit and annotate and highlight pages. That's not really stable either. One of my students just used DIGO and seemed to be perfectly happy with it. What most of them were doing was copying and pasting into a Word document and essentially generating a Word document which was their course outline and had chunks of material in it. Some of them this semester I've noticed are just printing out the cases. And in fact, if you were to print out the cases and print out each of my pages for each class, you'd have something that looked a whole lot like a casebook. My view of this is that this is not a casebook. I think the casebook model is over and done with. This is not a casebook. But students can sort of create a casebook if they insist on doing it.
This is actually directed more towards Steve. First of all, thank you for being the first person who has convinced me that there's a reason for PDF not to be expunged from the face of the earth.
I didn't say I liked it.
Second, let me tell you that I think I can make your life a lot easier. We have the full U.S. code in XML, addressable at the subsection level with full cross-references marked up, and conversion software to take it to PDF, with, I think, the exception of the cross-references. I'm not sure if we're doing those yet. We have that now. We will have CFR within a few months. And that's an offer that's open to anybody who wants to take it from us for Snake and Facebook purposes. We're happy to pass it along.
And I should have said, I actually refer to the LLI in our article. What I was trying to do here was basically go from scratch. I didn't want to use anything else, just to see if I could do it. I didn't want to use, there's also some things you could probably do using REST or LexisNexis, but I didn't want to start going down the road of creating a free competing product and then having them change licenses somewhere down the road. But yeah, that's...
For you, we can cut it.
Anything easier, yeah.